Injunction application brought before it by the Member of Parliament for Ofoase-Ayirebi, Kojo, Oppong Nkrumah. The injunction sought to challenge the constitutionality of a warrant issued earlier by the Chief Justice for High Court judges to sit during legal vacations. The warrant permits selected High Court judges to continue hearing criminal trials during legal vacation between August 1 and September 30. In his ruling, the Justice Gabriel Kwaman said the warrant issued are part of efforts for criminal cases to be heard expeditiously. Let's bring you more of what's contained in this. Wisdom Safo is with our research desk. He joins us live in the studio now. Wisdom, what do we know?
Yeah, Beatrice, so we'll be connecting to Lord very shortly, but we have to track the case, how we got here, right? So we go back in time to July 23, 2026, where CJ issued a vacation warrant. You rightly mentioned that he appointed Francis Achiponga Justice to sit on cases or conduct hearing during this vacation period between August 1 to September 30. Then on August 5, right, the defense lawyers for some specific pending cases, so the lawyers of the former NSB, National Signals Bureau boss, Kwabena Duboahin, and former NAFCO CEO Abdul Hanan separately petitioned the Chief Justice, and their dispute also later affected the Mustafa Abdulhamid and the NPA case. So they argued that the substantive criminal trials traditionally do not continue during the vacation without availability or agreement of counsels sitting on that particular case, and asked that the CJ withdraw the warrant and resume the cases in October. Then on August 10, right, GBA, the Ghana Bar Association, joined the dispute. So the Ghana Bar Association, acting on complaints from Zoe Atachia and Co. Company, Dami and Partners, Samokujetu and Associates, the firms, asked the CJ to uphold the established legal vacation practice. So it has been a convention, that's their argument. And its position was that the vacation courts traditionally handle urgent or interlocutory matters, and lawyers should not be compelled to conduct full trial during the recess. That was their argument. And CJ responded. So in CJ's response, the warrants were not withdrawn. So he said that in court, Justice Achiponga held that the warrants remained binding until revoked by the Chief Justice. And therefore, the Edubuahi and Mustafa Abdulhamid proceedings could continue and would not be injected or held, kept holding. So importantly, lawyers in the Abdul Hamid case said that they have not received any response to the petition at that stage. Then we went on, and subsequently, Attorney General responded. Deputy AG responded. Justice Tremsai, he rejected the GBA's interpretation of the whole situation. So his position was that the legal vacation reduces court activity but does not suspend the administration of justice. So there is no rule preventing substantive trials, and lawyers cannot unilaterally or by themselves decide when a court should sit. So he also said that if counsel is unavailable, the proper route is to seek an adjournment from the trial judge. That was the position of the Attorney General, the Deputy Attorney General, that Justice Stremside. And on August 14, Kojo Oppong Nkrumah, Ofoase-Ayirebi MP, invoked Article 2, 1, and 131, arguing that CJ's exercise of discretion raises constitutional questions and equality, administrative of justice, and proper exercise of discretionary powers. So his principal relief that was sought, of which we heard that it has been dismissed. The first relief was that the vacation warrant violates Article 17, 23, and 296 and are unconstitutional. I
will let you continue very shortly, but Lord Adjosara, Court Affairs correspondent, is speaking to our sister station TV3. Let's listen to what he's telling Mawina Egbeta on TV now, and then we'll come back to the studio here.
Announcing himself as a defendant for the Chief Justice. Once, especially, the Chief Justice has sent a judicial service personnel to represent him in the court. Now, in the ruling itself, Justice Gabriel Kwaman cited the fact that specialized courts had been set up to hear cases including galamsey, narcotics, cyber security, and then corruption and corruption-related issues. Now, he indicated that in lieu of this, the Chief Justice issued the warrant for these cases to be heard. And so once the applicant did not mention that these cases will be affected, it's not that it's just these cases that are being heard. It's essentially the fact that these cases are supposed to be expedited, and for which reason they are called the specialized courts. And so if you realize, the judges that were issued the warrant belong to specialized courts 1 and then specialized courts 2. And so on all this, Justice Pamang indicated that Oppong Nkrumah, the MP for Ofoase-Ayirebi, did not meet the threshold to, as it were, for the injunction to be granted. Now, I'd like to put a quote from the ruling. It says that, briefly, it says that the warrants issued by the Chief Justice are part of efforts to provide opportunity for more criminal cases to be heard expeditiously. Now, the fact that some criminal cases are not being heard during the legal vacation does not mean that the administration of justice will not be advanced to some extent. Again, he also stated that the fact that accused persons facing criminal prosecution do not usually take place during the legal vacation ought not to be the ground for injunction the Chief Justice's efforts at ensuring a speedy hearing of cases such as galamsey, narcotics, cybersecurity, corruption, and corruption-related cases, Marina. Now, from Davis and then the Ofoase-Ayirebi Member of Parliament, Kojo Oppong Nkrumah, they've been reacting to the ruling by the Supreme Court. We can take a listen now.
When you come to...
All right, and we'll get to hear more of the individuals that he spoke to. Frank Davis, we'll hear him very shortly, but let's conclude our conversation regarding the background to this case and where we are with Wisdom Safo, who is still in the studio with me. Wisdom.
Yes, so Beatrice, Oppong Nkrumah sought a declaration in his relief. The first one was that the vacation warrant violates Article 17, 23, and 296, and these acts were unconstitutional. And 2, he said that prioritizing selected special criminal cases amount to selective justice. And number 3, he said that compelling lawyers or judicial service staff to work through the vacation violates constitutional protection on working conditions and welfare. And also, Order 79, Rule 1 and 2 of CI 47 are unconstitutional to the extent that they permit such selective vacation hearings.
Thank you very much, Wisdom Safo. He is with our research desk. And let's hear Frank Davis, who is lawyer for Kojo Oppong Nkrumah, speaking to the press immediately after this dismissal.
When you come to court, you come to court with an anticipatory mind, with an anticipatory injunction application, whatever application you have before the court, or will be granted. So yes, the judge has made a determination. It is not in our place as lawyers to condemn the judge. We can only critique. The plaintiff has told you in very short terms his understanding of what happened in the courtroom. So we will abide the ruling of the court for now. We are not given to say the things other lawyers say. When decisions of the court are handed, it doesn't go in their favor.
And you have there Frank Davis. He's the lawyer for Kojo Oppong Nkrumah, and we'll be hearing Kojo Oppong Nkrumah very shortly. But let's have a quick conversation with Alex Abad. He is a lawyer as well. He joins us live on the phone. Good afternoon to you, sir. Thank you very much for joining us.
Good afternoon. Thank you for having me.
We just heard Frank Davis. He didn't want to criticize, as it were, the judgment given by the court regarding the injunction. What's your preliminary thought, really, on what has transpired? First, the application itself, and also the decision of the Supreme Court.
Thank you very much. If I heard your report at the last bit of what he said that the relief being sought from the court was that Order 79, Rule 1 and 2 should be declared unconstitutional.
Yes.
I hold a contrary view, and probably that may be the reason the Supreme Court dismissed it. I would have rather said that constitutional though they are, the way the Chief Justice had applied that provision falls far short of his duty to be candid as stated in Article 296, that there should not be ill will, resentment by reason of political persuasions, religious affiliations, whatever, sex, race, and all those kind of things. I would have couched it that way because, obviously, that provision takes into consideration a situation where something serious would happen and the Chief Justice will have to empanel judges to determine a matter during vacation. We all know how we use the legal vacation. And I hold the view that the legal vacation itself and the discretionary power given to the Chief Justice itself is not unconstitutional. But the way he's using it is what flies in the face of the spirit of the Constitution.
So what the Supreme Court did today, as you're aware, is not the dismissal of the case itself. It was the injunction. So the case itself, we are yet to hear as regards when it will be heard, among others. But having made the point you've made, though, do you anticipate that perhaps that could equally be dismissed as well?
Now, it is difficult to even predict what the Supreme Court will do. So let us just wait for them. But what is consistent now is that anytime they get an opportunity to assert their independence and all that, they mess it up. So let's wait and see what they say. So it is not lost on anybody in Ghana here that political considerations may have been the reason for the selection of these cases to be heard during vacation.
It means you disagree with the argument of Justice Kwaman that this is all part of the processes of getting cases expeditiously heard?
What about the other cases all over the country? What about the person who is waiting to get judgment so that he can go onto his land to develop it in the face of rising costs of building materials? So if we are talking about expeditious trial, why only these cases? What about the rest?
We'll have to end it here. Thank you very much, Alex Aban. He is a private legal practitioner sharing his thoughts with us on the dismissal of the injunction application by Kojo Oppong Nkrumah. Let's hear him very briefly.
Max, and then I'll let Senior Frank address you in detail. The court has dismissed our injunction application, but in the ruling, some very interesting pronouncements have been made. For the first time, the courts have admitted that some cases are being treated differently. Those are the words of the judge. They are being treated differently and expeditiously. Why? He doesn't say so. But then he proceeds to say that, in his opinion, that will not amount to a violation of the constitutional articles that we have raised in this particular matter, and that he thinks that that will even be in the interest of the accused persons. We've asked for a certified copy so that we can peruse it some more, and then on the advice of counsel, we'll take the next steps.
And you heard that Kojo Oppong Nkrumah, he's a member of parliament for Ofoase-Ayirebi. 15 minutes past the hour of 12. Stay with us. We're back with more.
Adamba, akwa
17 minutes past the hour of 12. Thank you for staying with us on the Midday News on 3FM 92.7. Now, the National Council of Parents Teachers Association has called for the immediate review of GES's recruitment system of security personnel. This follows the defilement of a 14-year-old special needs student at Bolga Girls SHS by a 72-year-old security man and his colleague at the school. Gapsin Kofi Raphael is the General Secretary of the PTA Council. He spoke to me earlier on TV3 New Day.
Our major concern has to do with the whole shock that we are hearing that one of the suspects is a 72-year-old man employed as a school security staff. Whether he was employed by the Ghana Education Service or by the school administration, they act on behalf of the Ghana Education Service. And they inherit both assets and liabilities. These are liabilities in the school space that we think that the public service and then recruitment procedures, if indeed it is true, something has genuinely gone wrong. Because a 72-year-old person, what business has he gotten to do with staying in the school to even play that role as a security man? Because the truth of the matter is that the school should not be retirement homes. Security roles require vigilance, strength, and sound judgment. So we demand the GES to immediately shift to recruiting young, better trained personnel of integrity for school security, not only school security, that is the non-teaching staff, for kitchen cooks, those who cook in the kitchen, for those who do labor works in the school. All these people, we should look at it that when we are recruiting them, we should make sure that we recruit people who have what it takes to actually manage the space for us.
Indeed.
So we are also demanding that the administrative justice aspect of which that they've activated the process with our interdiction. We demand that those staff should immediately be dismissed per the code of conduct of the GS and debar them from public service.
Indeed.
For 1 to 38 years. If you dismiss him and still get another space somewhere to go, he will only transfer that mindset and go and do another one somewhere.
Indeed. Thank you very much.
And we're also asking that a nationwide audit of all school security personnel, their age, background, and fitness.
And you have the Raphael, Gapsin Kofi Raphael. He's the General Secretary of the PTA Council. Breast cancer is increasingly affecting younger women, with cases reported in women as young as 22. At the annual General and Scientific Meeting of the Breast Society of Ghana, experts and survivors called for stronger national action and sustainable policies to close gaps in breast cancer care. Beatrice Soa reports.
Experts say 60 to 80% of breast cases are diagnosed late, increasing treatment cost and reducing survival chances. Stigma, financial constraint, and limited access to care continues to affect patients and families. President of the Breast Society of Ghana, Professor Josephine Nsofo, is calling for stronger referral systems and improved access to quality breast cancer care.
We need to also change our minds. If you notice something, say something. And breast cancer is curable when we get it early. It's true, treatment can affect your fertility to some extent, but most women, their fertility will recover and have children. So certainly, all is not lost.
Specialist at Kolebu Teaching Hospital, Dr. Marianne Dadzi, is concerned about rising cases among young women, some as young as 22.
We see a total of about 2,500 new cases in my center. So we are seeing about 500 new cases just in the center. But then we are finding out that we are getting more and more younger patients now, and they usually come in very, very late and very advanced.
She says the cost of treatment and limited access to care also affect patients' ability to complete treatment.
A lot of times it's because of the financial toxicity. The treatments are expensive, and then there are other things like distance. They may stop the treatment at a point, especially when they come in and the machine is not working and they have to go back. At a point, they will just not come again. Other side effects of treatment that they are not educated well about. And because of all these things, you have patients that are lost to follow up.
Speaking on behalf of the First Lady, Ladina Mahama, Deputy Presidential Spokesperson Shamima Muslim, says the reality where women sell their properties to cater for their breast cancer treatment is changing.
A woman should never have to choose between feeding her children and saving her own life. A woman should never have to lose her home to to pay for cancer treatment. And yet, this has been the reality for far too many Ghanaian women. But today I stand before you to say that that reality is changing.
For 50-year-old Dorothy Afenyo, her breast cancer diagnosis came as a shock despite undergoing several screenings.
I was doing the usual health screening. It wasn't picked up. And anything you see, follow up on it. Because when I saw the lump, I took it to one of our facilities and they just said it's nothing. But then one thing I would say that whatever changes you see in your body, pick it up and follow up on it. Maybe if I had followed up on mine earlier when I've seen it, maybe I wouldn't have to go through the treatment. But
Beatrice Soa filed that report. Pressure group Arise Ghana is calling for legislation to protect and sustain ongoing reforms in Ghana's agriculture sector. While acknowledging what it describes as encouraging progress, the group wants current interventions institutionalized, properly financed, and backed by measurable targets.
Agriculture remains central to Ghana's food security, livelihood, and the cost of food on the market. But for years, the sector has struggled with challenges ranging from high production cost and limited access to finance to inadequate irrigation and weak market linkages. It is against this backdrop that Arise Ghana undertook an assessment of reforms being implemented by the Ministry of Food and Agriculture. The group says its assessment shows that significant interventions are underway, including the Feed Ghana program, irrigation expansion, mechanization, seed and fertilizer reforms, and measures to improve post-harvest management.
We acknowledge that the Honorable Eriko Poku assumed leadership of the ministry at a time when Ghana's agricultural sector requires significant structural transformation. We dare say his visionary leadership is turning things round. The intentional actions to translate policy commitment into measurable improvements.
The group maintains that good policies alone are not enough. It wants the reforms to be supported by legislation, institutional systems, and reliable financing.
What we need is consistency, investment, accountability, and long-term national vision. So far, the Minister for Food and Agriculture is on track per our assessment of the policies he is implementing ambitiously. However, it is equally important we emphasize that the success of the leadership will ultimately be measured not by the number of policy announcements, but by what happens on the farms, in the markets, and in homes of ordinary Ghanaians.
The bigger test, however, will be what these reforms deliver beyond policy announcement. Arise Ghana says Ghana's agricultural transformation must ultimately become a national project, not a partisan one.
We are all involved in building a motherland.
There was a news desk report. In a separate development, the CSIR Water Research Institute has called for stronger collaboration and improved access to biodiversity data. The institute says that this will translate into supporting the effective conservation and management of wetlands in Ghana and across Africa.
Speaking to the media at the inception meeting of the Biodiversity Information Organization for Resilient Wetland Conservation in Africa Biopower Project, the head of the Marine Division of the CSIR Water Research Institute, Dr. Ruby Asima, said wetlands are increasingly coming under pressure. She attributed the growing pressure to pollution, changing land use, unsustainable resource use, and the impact of climate change.
Wetlands need to be paid attention to. They are not wastelands, like I said. They are very useful lands, and then they also contribute to general biodiversity. You know, biodiversity generally is connected. There are plants that maybe the animals, you have the whole entire food chain within that sector. So when one chain is broken, we don't get the full benefits of it. So we are encouraging that the wetlands should never be seen as wastelands, but they should be seen as resources for enhancing general biodiversity within the country.
Also at the event was Dr. Jacob Ejekum of the CSIR Water Research Institute, who explained that the biopower project will mobilize data on wetland, including information on plant and animal species and water resources.
We can use that information to make informed decisions. For instance, this year we recorded about 20 plants. Next year we're recording, say, 19 plants. Then we know that the biodiversity is declining. And so we have to put in actions that help us save that biodiversity, especially on the wetlands.
Professor Clementine Maromura also stressed on the importance of collaboration, biodiversity data, and stakeholder engagement in strengthening wetland conservation and management.
And that was a news desk report, and let's bring you some more here. And media practitioners have been cautioned against compromising a professional judgment as they adapt to evolving technologies. This was disclosed at a program by the GJA.
From artificial intelligence to social media platforms, newsrooms are increasingly relying on digital tools to gather, produce, and distribute content. But while these innovations offer opportunities for speed, wider reach, and greater audience engagement, veteran journalist and managing editor of the Insight newspaper, Kwesi Pratt Jr., says technology must not come at the expense of professional standards.
The central problem of journalism is therefore no longer simply access to information, but the organization of truth in a society overwhelmed by information. This is where the crisis of public trust becomes important. The public does not owe journalists its trust. Journalism must end it. Through accuracy and verification, fairness, courage, and the willingness to correct mistakes.
Grace Hamwajiman brought us that report. That's it for the Midday News here on 3FM 92.7. My name is Beatrice Sodo. Thank you very much for joining us this afternoon. Log on to srinews.com for more news.